Good afternoon. My microphone is now on. Well, welcome to our afternoon session on the second day. We hope that this is one of the most exciting of the topics that you'll hear about. I know there have been many exciting panels, and this one certainly is highly specialized, but we think very, very relevant to where the future of privacy is headed, and touches on one of the most intimate aspects of who we are as individuals, our genomes, and the privacy and data protection issues around our DNA, our genes, our chromosomes, and how those are relevant to the development of more personalized or tailored medicines, and the conduct of research in that context. I'm Hillary Wandell. I am the moderator of your panel this afternoon. I'm going to introduce the rest of our panelists in a moment, and I'll just tell you a little bit about myself quickly. I am currently the Chief Privacy Officer at Merck, and I serve as the chair of the International Pharmaceutical Privacy Consortium, which is a group comprised of leading pharmaceutical companies looking at privacy issues that are relevant to the kind of work that we do in our industry. And my background actually goes back to research work in the labs, but I also am a lawyer and have done a number of different things in my career that I hope are relevant to our discussion today. I'll next introduce Linda Avey. Linda Avey, to my left, is the founder of Brainstorm Research Foundation, a Research 2.0 initiative focused on developing virtual, consumer-centric strategies in measuring and tracking cognitive health for individuals at risk of Alzheimer's disease. In 2006, she co-founded 23andMe, Inc., a personal genetics company enabling consumer access to customized web-based health and ancestry information based on individual DNA profiling. And hopefully after our discussion today, many more of you, if you haven't already, will be interested in going to find out more about your own genomes. You can do that at 23andMe. I personally have done so and have found it quite fascinating. In 2008, 23andMe was awarded the Time magazine Invention of the Year and received the World Economic Forum's Tech Pioneer Award. Prior to founding 23andMe, Ms. Avey spent over 20 years working for molecular technology providers in the biopharma research industry. To Linda's left is Devin McGraw, who is director of the Health Privacy Project at the Centers for Democracy and Technology, where she serves she focuses on developing and promoting policies that ensure individual privacy as personal health information is shared electronically. She serves on the Health Information Technology Policy Committee, which is a federal advisory committee to the U.S. Office of the National Coordinator for Health Information Technology. And she also co-chairs its Privacy and Security Work Group. She is a magna cum laude graduate of the Georgetown University Law Center and received her Master of Public Health from Johns Hopkins University. To Devin's left is Gil Segal, who is a professor at the University of Virginia School of Law and Kiryat Ono College here in Israel. He is a surgeon and health law professor, and at Kiryat Ono College here in Israel, he directs the Center for Health Law and Bioethics, and as I understand, he's responsible, I learned over lunch, for actually approving a lot of the genetic studies that take place in Israel, so he'll have a very interesting perspective to offer to us. He serves as a member of the National Committee for Human Subjects Research here in Israel, the Committee for Non-Medical Sex Selection, and is a member of the National Advisory Committee on Genetic Information. His areas of expertise are biotechnology, patients' rights, and comparative medical ethics. To his left is Tanguy van Overstraten, who is listed among the leading lawyers recommended in the technology, media, and telecommunications. He is the global head of Linklater's privacy practice, and he is also the global telecommunications sector head of the TMT group in Brussels. He has over 20 years of experience in advising multinational companies on local and international transactions and regulatory projects focused primarily on privacy, outsourcing, and telecoms. He regularly contributes to conferences as a guest lecturer and is a guest lecturer at the Solvay Brussels School of Economics and Management. He graduated from the University of Brussels and holds an LLM degree from the University of Chicago Law School. And I will turn now to our chair, Professor Hiroshi Miyashita, who is with Surigudai, or Guadai, I apologize, University, where he teaches constitutional and information law. He served as the first Chief Privacy Officer of the Cabinet Office in Japan. He currently assists as legal advisor for the Consumer Affairs Agency, a newly established in September 2009, which supervises the Japanese Act on Protection of Personal Information. He has been active in the OECD, APEC, EU, and other international fora for contributing to cross-border cooperation of enforcing privacy laws. So with that, I will turn the stage over to Hiroshi to introduce our topic today.
Hello. Welcome to the very new generation of privacy sessions. Well, let me begin with a very provocative remark. It is often said that health is better than wealth. Now, can we say privacy is better than health? Since I am a greedy man, I want both privacy and health. So the question is, how can we balance these fundamental values of our life? One of the most difficult tasks of my experience as a regulator in Japan is balancing these compatible, but sometimes competing values between medical research and privacy. This is a difficult task because regulators, including me, do not have enough knowledge on how the personal information flows in medical research, and who handles the information, and whether the information is successfully anonymized or not. We now live in an age of better quality of life and better health thanks to the great advance of medical research. Medical research is essential to identify the causes of disease, to examine the efficacy of treatments and preventive measures. On the other hand, medical information is regarded as highly sensitive data, highly sensitive information. Medical information, especially genetic information, exactly defines who I am. Medical information is the human essence, not even know whether it is mine or not. Medical information is somewhat different from simply personal, socially constructed facts about ourselves. So now we face the exceptional balancing between the medical research for a better life, better quality of life, and privacy for our dignity. Let me put some questions for the panelists. My very honest questions for the panelists who are very professional and specialized in this field. The first one is that who are the key players of the medical research and personalized medicine? Who should play the main role of protecting privacy and data protection? Medical research often takes multidisciplinary approaches and researchers from various health professionals. So who would be the possible and who would be the key players? My second question regards to the privacy principles. Which privacy principles are crucial for protecting privacy in medical research? Can the consent of the patients and their family work well? Can the patient have the right to access to the research result, even if the research is conducted outside his or her country? How can we assure the transparency and accountability in the course of very, very complicated mechanism of medical research. My final question regards the data transfer and the privacy frameworks. Can we set a common standard of ethical, legal, and technical framework for medical research and privacy protection? How should we address data transfer issues? Declaration of Helsinki, which was very recently revised, the final version in 2008, shows ethical principles of medical research involving human subjects, mentioning the protection of life, health, dignity, integrity, the right to self-determination, privacy, and confidentiality of personal information. If this declaration is a possible leading guidelines, how can we collaborate among regulators, researchers, doctors, and other stakeholders? I hope, and I'm sure, all the panelists will respond to the question. Thank you.
Thank you very much, Hiroshi. So we're going to start with a mini case study, and Linda's going to lead us through that in a moment. But before we do that, I did want to say that we hope this will be a very dynamic session. So we have very few slides. We hope to be challenging each other much up on this stage, and we would like you to do the same. So please, if you have questions, don't hesitate to raise them throughout to any one of the panelists, and we'll make sure that we're addressing them as part of this panel discussion. So with that, I'm just going to see if I can appropriately navigate the slides here. And oops, I navigated too far, unfortunately. Very sensitive. So as I mentioned, Linda's going to walk us through the mini case study that we've prepared to help you understand how complex the way in which data flow within the healthcare clinical space and its connectivity with the healthcare research space. Oftentimes there are a lot of overlaps, there are identifiable data flows and coded data flows, and between and among various different parties. And so we wanted to start with a case study to introduce that concept and then talk a little bit more about the data flows associated with that. So, Linda?
Thank you, Hillary. Is this on? Okay, great. Thank you. Okay, thanks. We'll go right into this case study, but before I do that, I just would like to see maybe a show of hands of people who are familiar with the concept of personal genetics and companies like 23andMe who offer these types of services. That gives me an indication, at least, that I'm not talking completely out of left field. So recently, there was a blog that came out from a gentleman by the name of John Sternberg. And so this case study that we're using today is not theoretical. This is a real event that happened. And what occurred was last April, there was a celebration of DNA Day in the US, and or maybe it's a global thing. And so 23andMe, the company, in celebration of DNA Day, offered its services for a very discounted rate. And a lot of people decided to jump on this at a reduced cost of $99. So this gentleman in New York ordered a kit for himself and his wife, and they both provided a saliva sample, and when they got their results back, they were going through their genetic information, and the wife found out that she was a carrier for the BRCA markers, which remarkably increased her risk for breast cancer. And because of this information, it really kicked off a whole chain of events for her as an individual that is now facing a lot of choices about what she can do proactively and preemptively to prevent developing breast cancer. And so she went through the process of going to her physician, and first of all, they confirmed the results. So getting this genetic information back from a company like 23andMe may not be what you want to base a major decision on as far as the steps that you can take to prevent certain cancers. But they went through that process, they confirmed the results, and talked to a genetic counselor, went through a lot of counseling. about what really are some outcomes that we can choose in order to reduce risk. And so she did go ahead and decide to go with preventive surgery. She had a double mastectomy, and now is really living with those consequences. But this whole idea of having access to genetic information now at a very personal level is causing these kinds of outcomes. And we really wanted to try to use this as a case study for discussing, first of all, having access to this information. Is this something that an individual should have a choice for? And we believe, certainly at 23andMe, that you do have this choice, and you should have this choice. And whether or not your doctor is involved in that decision is another big question. Right now, you're able to go online, order a service like this, and you don't necessarily have to have your doctor weighing in on that decision. And there's a lot of debate certainly going on in the U.S., and the regulators are now stepping in to have discussions about this. But the bottom line is that we think this case study will open up a lot of the debate around this opportunity and the information that is revealed through this, and then how does that now become part of your personal health record? How does that become a discussion point with you and your doctor? And how does that really influence family decisions that you have in front of you? So that's sort of the backdrop for the case study.
Thank you, Linda. So I'll just quickly take a moment to walk through what we have set up here on the screen, and it's based off of what Linda just said. And this is just to give you a little bit of additional context to think about data flows and to think about who has access to what data and what kinds of controls should be in place. So, you know, who should be responsible and what principles should apply. We'll get into a big discussion around that. So a few quick things that you see up on the screen. Again, if this proposed case study is looking not at a specific individual, but a hypothetical individual, female, age 35, of Ashkenazi Jewish heritage, tests positive for DNA mutations in the BRCA1 and BRCA2 genes that are known scientifically to account for the majority of hereditary breast cancers and ovarian cancers among women with her heritage. Similar to the real-life situation that Linda shared with us, in this case study, the woman would share the results with her primary physician, of course with a genetic counselor, and ultimately with an oncologist. After further clinical genetic testing that confirms the results from the direct-to-consumer testing company like 23andMe, she elects to undergo preventative surgery to reduce her risk. After doing that, she and her brother, who possibly has a similar genetic profile, opt to participate in a clinical research study conducted by the research center at the same research institution as her oncologist. So, say, for example, her oncologist is based at a hospital here in Jerusalem, and that there is also an academic research center associated with that hospital conducting clinical studies on these potentially new treatments to treat individuals with these kinds of genomic variations, or with cancers that have these, that seem to result from these genomic variations. She and her brother opt in to participate. So they sign informed consent, they participate in the study. Her sister and her aunt, again, who may have a similar genetic profile, opt to participate in a translational research study conducted by a collaborating industry research team. So that may not involve any actual intervention between a healthcare provider and the aunt and her sister, but rather may involve, for example, data that came from their medical records being sent to the industry research team that's looking at developing new therapies and understanding how maybe its existing therapies could be applicable to people with these genetic profiles. Those data then would be sent to that industry research team. And then a third possible scenario that could happen, hypothetically, as a result of these initial findings, is that she, as a mother, decides to donate blood samples that previously had been collected from her children. Perhaps they had gone and had some other testing done and there was blood stored on them, or maybe even blood stored from birth. Maybe the cord blood had been stored from birth. Perhaps those are sent to a governmental research team, and this is to give you the array of different types of researchers that could be involved in this, these various different types of research studies that taken together could provide us much additional information about the meaning, the clinical meaning and the clinical utility of diagnosing people with particular diseases and conditions based on mutations, or the risk of them getting these diseases and conditions based on the mutations that have been seen in these genes. So that's just to set the stage, and we thought we'd show you, before we get into a discussion around the privacy and data protection issues, I thought we would get into a discussion around who needs access to what data. So to help facilitate that, and each of our panelists is going to say a bit more about who needs access to what data, you see a big map of data flows up on the screen, and we're not asking you to understand exactly how all this data is flowing all over the place at this point, but a few things to try to differentiate for you quickly. Up in the upper left-hand corner assumes the patient. So the patient interacts with a direct-to-consumer testing company, sends in some saliva, which is then analyzed by a testing lab. Usually the testing lab doesn't necessarily need to know the name of the patient, but does some analysis. Also, the insurer who might, well, let me say, then the woman contacts her healthcare provider, who then contacts a specialist. So there's some things happening in the clinical care setting and the direct-to-consumer setting, and that's what you see on the left-hand side of the screen. On the right-hand side of the screen is the research. So whether it be the academic researcher, the lead research institution, or collaborating research institutions that might be involved, whether they be from the government, from industry, from other academic research centers, or people just collaborating together on some big multi-center study, which happens all the time, there is a potential with this one diagnosis for there to be many, many different data flows across many, many different players. And this is potentially a very sensitive topic where it's really critical to understand who needs access to what data. So I'll start by turning back to Linda and asking her, and of course the other panelists too, to comment on who needs access to the clinical data.
So, you know, the way you could diagram this out actually could be to have the patient right in the middle of all of this flow, because from the perspective that the data that were generated that started this whole conversation really came from the patient making a personal choice about accessing that. And so having that decision come from a patient and then, or a person, if you want to call them that, because we're all patients, we're all people who have these choices, but to have access to the clinical data then, it's how do you define clinical data is the first thing we need to discuss. It can go from being pretty interesting genetic information and turn into clinical data when it has implications like this woman discovered. And so that process, that decision of her now taking that from an online resource that her doctor doesn't have access to, now moving into the healthcare space by her making that decision that my doctor needs to have access to this. So that flow could be turned around where the doctor might have ordered it and it immediately became part of her electronic medical record. That's another path or another regulatory construct that is actually being debated in the US right now of whether that's a requirement. And then certainly if we move to a point where DTC genetic tests are reimbursable, then obviously that's when the providers are now stepping into the ring, and they of course would have to have access to that information if the patient were to be reimbursed. And testing laboratories, as you mentioned, don't necessarily have to have the identifiers of the individual. We're able, certainly at 23andMe, we're able to keep that information out of the testing lab's records. They just have the genetic profile and that gets served back up based on a barcode. So, but then there might be future tests that get done that might want to be correlated back to that person. So then that could potentially open that up for the testing lab to have access to that too. And then the choice to have this information go into the research centers, what we're finding is that a lot of patients want that data to go into research labs so that there's more utility, that the more researchers who get access to it, the more progress we're going to make. And if the patient's at the center saying, I'm deciding that I want to take my data and I want to forward it off to the leading breast cancer research centers in the world, that is a patient's choice to do that. And so I really, by putting the patient at the center and making the decisions on where the data go, I do believe that that's the right construct for this.
Thank you, Linda. So I'm going to look at Gil now and ask you, first of all, if the patient's not at the center and the patient isn't able to give the permission that obviously would be ideal, first of all, how might we deal with a situation like that in terms of the data flow? And how, just a secondary part of that question, how does the data really need to flow in the research setting?
I think that for this multinational crowd, I think we have to make a very powerful distinction between two different scenarios. One is that the patient is in control, and he initiates, so he's the generator of the process. In many other countries where we have, definitely, especially when you have a national health system, usually the generator comes from a medical perspective. So in Israel, you reach the age of 40, so you have to have a mammography, you have to have a BRCA1 if you are in a risk group, if you're going through a pregnancy. So there's the medical opinion how to generate information. And once that medical opinion runs the system, so to speak, and it's not centered on the patient's volition, then this creates a different paradigm of handling that information. So if you're into the business of the patient, are generating the information, and then I send out, I dispatch my genetic samples, and then I retain them back, I return the results, and then I make decision who gets to what, and that's one scenario. The more common scenario is that those pieces of information are retained by national players, or at least local, regional players. And then the flow is really a fascinating question about who should have access in the sense of who owns that information. And this really pertains to two different sets of arguments. The first argument will be, listen, there's no way we could have come up with the BRCA1 unless we had the entire group of Ashkenazi women come together as a group and share their genetic samples, and then we can decipher, we can find out what's going on. So there's a collective move in that sense. So there's a public health aspect, even within my personal genetic or my personal genetic information, there's a public claim to that. And that doesn't mean that we have to outstrip everything, but there is something that to be said about letting that flow go within a more collective fashion. And this is very familiar with European ideas and Israelis and other places as well. So we have to get this distinction between, are we in there for the patient or something that is a patient's group? And then you have to decide, you have to opt which path are you on. But if you're in the path of that, this is something that we all have a stake in, that there's a collective interest, then the answers then will be answered in a different way. So it really depends on which hat you want to wear. And this goes to the notions in your society, the solidarity, the me versus the others. And again, and don't get me wrong, there's no binary, there's a yes or no, but there's this aggregation of interests that you have to play in. And then, once you make that decision, then your regulations and your laws and how tight the access should be and how much effort you're going to put into that, that's already the second line of answer.
Thanks, Gil. And I think so. We've heard from Linda and from you about both the individual benefits of some of this research as well as the public health benefits of other types of research. And sometimes the research that comes from individuals does benefit the public health as well. I think it'd be interesting now to maybe hear from Devin and Tanguy about the risks. So we talked a little bit about the benefits, and I think Hiroshi certainly challenged us at the outset. We need to also talk about the risks. I mean, obviously we want public health, we want individual health, but we also want privacy, and how can we have both of these? I think in order to do that, we need to talk a little bit about some of the risks to individuals about this information flowing and being shared throughout this paradigm.
So I've seen data flow models before, not necessarily specific to genetic data, but other types of health data, and they're usually much scarier than this one. And the reason why this one is not as scary is because we thought about what are the sort of known ways that the data would need to be shared in order to advance clinical care on the one hand, and the research enterprise on the other hand. And in the case example, it was, you know, the patient was, it was completely within her expectations because she made those choices. In the other scenario that Gil laid out, the patient may not necessarily have been aware of it, but we're talking about sharing among regulated entities and probably, again, consistent with mostly with what the public expects. Some of these diagrams that you have seen expand out tremendously, in part because they also include data that is so-called anonymized or de-identified, and I'm sure we'll talk about that. But in terms of, there can be data flows that are beyond the sort of circles that we would all that we would either expect as a member of the public or that we anticipate need to happen in order, again, to advance our two aims here, clinical care and the research enterprise. It is when the data really drops out of those buckets that there are risks, and I think that they're particularly present in circumstances where the patient doesn't necessarily know that all of this has happened because the providers are sharing the data either because it doesn't qualify under regulations as being identifiable, which is still the case sometimes in genetic data, but not so much with genetic data as with others. So I often think about the risks in two ways. One is the risk to patients as individuals, which is the likelihood of discrimination, for example, loss of a sense of control or privacy if their genetic data is exposed beyond what they have come to expect. There's also this notion of genetic determinism, where if I have the gene, I therefore am sick, even in cases when it's not necessarily the case that you will get sick. In the case of the BRCA1 markers, of course, the chances are very high, but with the other genetic markers, the risk that you will actually come down with the disease may not be that great, may be largely controllable. So in some respects, it depends. But there is this sort of harm to individual sense of it, and it doesn't have to be financial harm in order to be cognizable as a harm. But I think the second layer of risk, which may even be a greater risk, is the loss of trust. The loss of trust in the system to protect my information, which trickles down to people being afraid to seek care, being afraid to swab their cheeks and have a genetic test done in order to know more about what they can do to reduce their own morbidity and mortality. But also lack of trust in the research enterprise. If the data is mishandled in some way or exposed or used in ways that I did not contemplate, then I don't trust researchers. And it doesn't have to just happen to you in order for this to happen. There's sort of this collective, aggregated loss of trust that comes from stories about misuse. And it doesn't need to happen to you as an individual for that loss of trust to occur. So we sort of have the risks that are really on two spheres here.
Thank you. And Tanguy?
Yes, first of all, I would like to, is that working? Yes, I would like to do a warning just that I am not a scientist. So I'm a legal person, I'm a legal mind, and also I'm a legal mind who is, whose expertise is in the EU. That's working now. I would like first, before answering the issue of risk, come to two elements which I think should be addressed before we identify the type of risk. The first one is the format in which the data will be shared. Because I think we have been talking about transfer. You've seen on the chart that we have two sorts of arrows. One is a black one and the other one a green light. And you see that for the arrow in black, we have identified the data flow, meaning that we have identifiable information that are linked to an individual. That's, I think, crucial for the determination of the risk here. The second point is coded data flow that you could also use as pseudonymized data flow. I know there was a session this morning on that and the anonymization in general. I think this is very important because it is also linked to another concept, which is the role of the parties, the role of the different actors on the chart. And when I look at the chart, well, I could even question some of the arrows. So you may wonder, for instance, whether the insurer, the payer, really needs to have access to the data non-anonymized, non-coded. That's a question mark. I think it's interesting to discuss that later probably. Based on all that, I think I can see risks at least at 4 levels. The first one is a risk which is purely factual. Just figure out the situation where the insurer received the information and as a result of that information decides not to renew the insurance coverage later on because the person is flagged to be a risk in the future. That's, of course, an obvious adverse situation for the data subject. Second point is, of course, sorry for that, I'm a lawyer, as I said, the purely legal environment and the legal risk. And I think this is very important nowadays. We have talked about the full day yesterday and this morning about enforcement, accountability, but also prosecution and sanctions at the end. So I think the second risk is, of course, for the various actors, to the extent they would not be compliant, to have to pay fines, how gods know what could happen else, I mean, imprisonment and so on. The third layer, I think, is a risk which is less quantifiable, but which is, I think, perhaps even more important, because I think even more concrete, is the reputational risk. You don't want, as a researcher, as a pharmaceutical company or biotech company, or as a research center, to be flagged in the front page of the newspaper because information that you were using in the framework of a clinical trial, for instance, were used for completely different purposes. That's something that, of course, companies or organizations do not want to face. And the fourth one, and there I completely join your position, is the risk of damaging trust. And at the bottom line, I think it is probably the most important one, because, of course, research is relying upon people and patients at the end of the day. And if those patients do feel that their data is at risk, that they face adverse effects, adverse consequences because their data have been processed in a wrong manner, in an illegal manner, I think that will be the end of these clinical trials. Of course, to a certain extent, some of them will go on anyway because there's no way to escape them, but there will be a risk, I think, that people will turn away some possibilities to expand, of course, the scientific knowledge and the medicine in general.
Thank you. So I think what we've heard around this potential, or this hypothetical set of data flows, which is simplistic, it could and oftentimes is far more complex than even what you see up here. It could probably maybe be exponential in terms of the number of data flows. But what you've heard is a few key things about the potential risk of harm to the individual, to the players within the space who are actually trying to advance healthcare, advance medical research, and so ranging from concerns people might have about how their genetic data might be used to discriminate in insurance coverage, from stigmatization in how they're perceived, from concerns about genetic determinism as to whether the fact that they have a particular variant or a particular mutation means they're going to get a particular disease, to concerns about, well, what are people really doing with my data? Can I trust what they're doing with my data? And so I think what we're hearing is that there really is a complementary role that good privacy and data protection, properly designed into personalized medicine, healthcare research, and even the clinical setting around privacy is actually, it can serve to further bolster the development of new innovative treatments to advance healthcare and to advance the public health as a whole. So I hope as we go into our next slide, we can explore that a bit further. Again, we do welcome you all to interrupt us at any moment. I know it's always difficult after lunch, and you've been in many sessions for the last few days, and we're talking about complex things. But please do challenge us if you disagree with with any points or you want further information or clarity around a particular topic. So moving now away from the case study, the data flows, and getting more into, well, how can we use privacy to further advance the development of personalized medicine and healthcare as a whole? I'd like to ask Tanguy to actually give us an overview of the concept of privacy by design and how it might be applied in the context of development of personalized medicine, approaches to personalized medicine.
Well, there was, of course, a plenary session this morning on the topic, so I was a bit bypassed. But anyway, I think what I would like to say, I would like first to insist on one point in relation to privacy by design. I think it's first a great concept. I like the principle, and I hope that many companies do share my opinion. The next question is, of course, how do you organize the, let's say, not necessarily the enforcement, but at least the organization, the structure of that rule in the practice. And I think there are, in my view, several layers to consider. The first one is really the principle, the fact that people do agree that they have to be proactive, as was explained this morning, and they have to consider privacy from the outset, which, by the way, from a purely technical point of view, is the much easier way to handle. It's much more difficult, I can tell you from my experience, to fix the bugs when they occur. It's much more, it's easier, although it's of course time-consuming and cost-consuming, to anticipate and try to figure out the issue before they occur. That's the first layer, I think. The second layer, in my view, is to define how to achieve that and to determine that from a definition of a purpose. I think it's to define a goal. And the goal could be, for instance, data minimization. In the framework of a clinical trial, you may think about, and again, looking back at the slide, the previous slide, you may think about who among all those actors really need to have access to the data. It was said this morning that, you should start with the presumption, with the assumption that there is no need to have access to any sort of data. Well, we know that in this particular framework is more or less impossible. I think there was also another session this morning about data anonymization, which shows a little bit the opposite, unfortunately, because if you want to really develop personal medicine, you obviously have to get as much information about individuals as possible. So that makes it a bit contradictory and a difficult paradigm. But then I think where I really want to raise a point is the third layer, I would say, when we talk about means. And there I think I would very much advocate in favor of self-regulation. Because I think if the regulators start to tell companies how they need to implement privacy by design, that will be extremely difficult. I think it is important not to, to provide a goal, that's certainly an issue that should be tackled, but not to provide the means. The means will depend on the situations. To prepare this panel, I read through some of the exercises that have been done by certain prominent companies in relation, for instance, of health records, and I can see that they are developing progressively tools that enable privacy by design, that are really embodied in the way they are handling and structuring their applications, but they are free to determine that. The sole point which is important is the purpose to try to minimize to the maximum extent the processing of data, make it clear that those processing take place within the framework of specific and defined purposes, and so on. So basically, the message I would like to give today, and of course, please feel free to challenge me if you disagree with that position, is that there should be perhaps a very high-level review of privacy by design, and this should be, I think, something that would be a principle to be followed by the various actors, but leave them alone to the extent they need to design the means to achieve that specific purpose.
So thank you, Tanguy. And if we, yes, Anne.
no disagreement at all. We spoke afterwards. I just wanted to add one thing, and this may surprise many of you. In the context of health data and health research, it's different in terms of the identifiers that are required to be attached to the data, not necessarily in terms of how the data are used in the context of research, but the researcher may have to work back at some point to an identifier to link with actual medical identifiers. And the way we've done it in Canada, and I should tell you, privacy by design is possible, but different. You have to modify, just as you were describing in this context, because there's enormous value in terms of health data to real-life identifiers. You know, how is the person? What other attributes are associated with them? All of that inform the outcome of the research. It's absolutely critical. And health research is absolutely essential. You must say that. I always say that, you know, first as a patient and then I'm a privacy commissioner. When you're ill or when there's in need of health research, it is extremely important. So it's one of the very few areas that I distinguish. Even if you look at epidemiological research, even a very small percentage of people opting out can sway the results dramatically. So all those qualifiers, by way of saying, what we do, one of the things we have in Toronto is what is the center called at Sunnybrook? ISIS, the Institute for Clinical and Evaluative Studies. And what they do is they get identifiable health data, like 2 people see it in identifiable form. They scrub the data, they have an excellent pseudonymization technique, and they create a unique identifier that is meaningless. And that identifier travels with the data, so researchers see nothing in terms of actual identifiers. However, if the need arises that they need to link back to find the real life, you know, correlates, there is a means of doing that. And we audit them, we've looked at it many times, and they've never had, in the you know, over 20 years I've been there, they've never had a health data infraction in terms of privacy. So I just wanted to say that to support the need for health research, that it is possible to apply privacy by design in a modified way. And the final comment, our electronic health records in Canada, there's a federal organization called Health Infoway. I don't know why they're called that, but they are. And they are, in fact, a privacy by design ambassador. We work very closely with them and the systems they've developed for how to deal with health data in a way that is consistent with privacy by design, but still renders enormous value to researchers. We've worked that out, and it's ongoing. So if you go to our website or theirs, you can get more information on that. Thank you. I agreed with everything you said.
Until the mic gets there, there's a hand over there. I'll just say that the last remark, I think, hits a very important accord, and here I'll speak for the medical and scientific community. That is that we know what our prime goal is. The prime goal is getting there healthier, live longer, and and the way that you design the system from a regulatory will have an enormous impact on the progress of science. And there are real people at the end of the day that needs that data. There are real people that can benefit from the remedies we're going to come up with. So, and again, now I'm going to change hats, go back to the law aspects. But again, we as lawyers, we as lawmakers should be very well aware that there is a real aim at the end of the day, and our regulation should reflect that.
There was a question in the back?
Hi, I just had hi. How are you? I just wanted to make a comment about privacy by design. I think it's absolutely possible in the health context. I think I would caution, however, against the purpose being data minimization. I think from my perspective, I work for industry, and from as a sponsor of research, I think it's important that we all keep in mind not only the public health safety aspect of things, but sort of how research actually works in reality. The reality is that half of medical advances and findings and cures and medicines happen kind of on accident. It's a trial and error process, and sometimes having the more data helps us get to a better end result quicker, or avoid a bad result, frankly. So I think while privacy by design is a great thing to sort of incorporate, I'm not sure data minimization is the way to go for a purpose.
So thank you, Mina, and I think Anne has a response to you, and then we're going to let Pierre use comment, and then we're going to come back to this slide, because I think one of the things we do want to point out is that you don't see the word data minimization on this slide at all, so we will definitely get into that, but I think there was a response.
I just want to be clear, data minimization is absolutely an important attribute of privacy by design, but not in the context of health data. I mean, that is a general goal, sort of an all-purpose in terms of privacy by design, and it prevents a lot of flaws and faults, but the goal here is you want data, and you need it in some identifiable form at some point in order to render it of value. So I think this is an outlier in terms of an area that needs a different approach. It's still a privacy by design approach, but that one attribute of data minimization I don't think would apply well here. And even I talked to Paul Ohm after his talk. I couldn't attend his session, and we talked about the whole point of can you de-anonymize, and of course you can, but you don't want to anonymize here. You want to have certainly pseudonymous identifiers, some identifier that travels with the data that does not link directly to the individual's identity, but you should be able to flow back to it because you need that for medical research purposes.
If I may add one thing also from a regulatory point of view for the organization of clinical trials, well, the sponsor has the obligation to report side effects and so on, so there is a need to make a link with the individuals. What I wanted to say about data minimization is to start with something, of course, but also to consider the various actors in the framework. If we look back at the previous slide, well, there are some actors, in my view, who do not need to have access to all data. And that's the question, how do we allocate that? How do we format the various transfer? Also, I think one element which is key in all this, we didn't mention any country on the slide, but of course the transfer will largely depend also on to which country you're going to transfer. That I think will have also an impact.
So I said we wanted to be very dynamic, and I see it, and there were a number of comments in the audience. I want to thank Pierre Yves. We had a question in the back. I think I saw Marty's hand. Was there anybody else?
Yeah, I do, Hillary, I do not agree with some of the comments that have been made about no need for data minimization with respect to health data, because I don't think that's right. I mean, I think it depends on what you mean when you say data minimization. Right. But it's part of we don't have the word data minimization in there, but when I think about framework and what is included in an application of fair information practices, which should be present in every use of health data, even those that we want to encourage, collection and use, data minimization, use what you need, don't gather more, that should always be present, even in health.
And I think the one comment I'll make in response is, and this is just a personal feeling about the word, and I apologize for anybody that I might offend by saying this, but the concept of minimizing data, as we know in the health research context, can lead people to believe that we're not evaluating all the necessary information to really give us the proper understanding of what is the real health issue, what are the real causal factors, how can we develop better treatments for the public health problems. And so the word, I guess I like better, and this is just maybe the American side of me coming out, but I like the word minimum necessary, because it's what data do we need to conduct research effectively, to understand better what the health problems are. It's not that we want to collect all the data there possibly are in an identifiable way, but what data do we need to collect in order to properly evaluate what the real health risks are. So it's using then only the minimum information you need, but I just like that terminology.
Getting what you need. It's not a static concept. It's
for
very
the legitimate
flexible
research purpose.
And then just really quickly to kind of flip that on its head, why don't we give consumers the option of them deciding what data that they want to put out in the open? So George Church at Harvard has an excellent program, the Personal Genome Project, where the early participants in that were, you could only participate if you agreed to put out not only your genetic information, your full sequence on the web, but you also put all your health records out. And it was a really big hurdle. I think it took George about a year and a half to get this through the IRB at Harvard. But the point is that let's let people make a decision on this. If they want to do it, why not let them? And so instead of regulators and policymakers and doctors and physicians and researchers and everybody else making a decision, why don't we let consumers do that and patients do that? Because again, the more serious disease they have, probably the more open they're going to be. And you can't understand, you can't put yourself in their shoes until you're in that same situation where you're diagnosed with ALS and now you don't care about anything other than hopefully helping your children and other people who might get that disease. So and that consent process changes based on where you are in your life. And if you're totally healthy, you may have a completely different, thought on this than if you're suddenly diagnosed with a very serious disease and you don't care if everything is out in the wide open. So I think that we need to bring that into this conversation, because I think we're all maybe going to be faced with that choice, and maybe that is something we're going to want to do.
Thanks, Linda. So, Pierre Yves?
Yeah, I introduced this morning during the session anonymization, also the notion of consent, and it's about the same thing, because in a clinical trial, you consent only to a certain purpose. So your data, your blood, your tissue sample will be also only used for a certain purpose. And of course, now if we do biobanking, it's because we hope that with the sample that we collect, we will be able to make correlation with other diseases that we don't know about today. And there is a great difficulty now as in Europe. If you apply the European regulation by the letter, it is not possible to bank samples, because you cannot tell for what exact purpose you are banking this sample. And this is really a question for regulators at the time being. You can have a one-by-one decision, but there is no guidance that tells you under which condition you can bank samples for future research, which is not known today.
How can you know what you don't know, right?
Actually, the Karolinska in Sweden had a very nice study on that. They actually followed the UK Biobank project, and in Karolinska they actually said, let's see what the people really want, taking after your lead. And clearly, overwhelming majority, over 85% of people said, quite frankly, we have a high level of trust in our scientists, and as far as the project is authorized by local IRB, and we have given a general consent, that is a workable solution to not to incur unreasonable costs of recontacting for every single use of it on the one hand. On the other hand, not taking away a person's control over his sample. So one very nice way is to entrust, like in democracy, I entrust my representatives over those decisions, giving a general consent. But just one quick remark to Linda's point. Let the people decide. Quite frankly, that's a nihilistic statement in a way, just because at some very basic level, you do need experts to give an opinion on what are the risks, what did they entail. I mean, just think about the complexity of genetics and let people understand. I mean, if you ask me, quite frankly, I can assure you, if you ask 100 healthy individuals about the risk of genetic discrimination, they're going to go bananas. But if you look at the actual real-life risks, they're almost non-existent. So the fear factor is going to going to do us a bad service, as opposed to a way where I'm here not putting myself in that position, but we, the experts, can evaluate. Same way we do experts on cell phones and tumors, and we have experts because there is a role for experts, and this issue is not different.
So I would ask the two of you, while we're going back to take the rest of the questions from the audience, to think about the risk of selection bias and how we can address that, or possibly how to address that, especially in the context of retrospective analyses, epidemiological analyses, those kinds of things. So let's come back to that, but I think there were some people patiently waiting in the audience. Yes.
In the context of medical data, we very often hear the argument for it all being very open, because saving lives is the most important thing, and we heard this a lot here actually now as well. But there's another side as well, a flip side of where people are afraid to go to, for example, psychologists or psychiatrists on record, because they're afraid of that being written down. So this is also going to skew your data, because now my HM
so that we actually can do good clinical care, get the data we need to do that, but also be able to use it to generate information that will lead to better cures. All of that is very important, but if we do it in a way that violates people's trust, we might as well throw it all out the window. And it will only take one or two bad actors for that to happen, which is why self-regulation should be a layer on top of a baseline of some very strong protections that no one should be allowed to ignore. But you can certainly encourage companies to do more and to do better and to implement privacy by design in innovative and creative and effective ways. But that's exactly the risk here. And I think I would raise another point, which is we just assume that everything called research is good. Is that true? What is research? When is it good? When is it not so good? I don't think we always know the answer to that question. It's often a very normative one, and that flows into the trust equation, I think.
And I don't think IRBs necessarily can
IRBs,
make that
exactly.
determination.
That's IRB. Yeah, but just to follow on that, that is exactly why when at the law school it's very easy. You have the students coming in. There's this case and these are the individual's interests and what are the other interests. And I always tell them, do not make the mistake. A patient's right for confidentiality is not individual interest. It's a public interest. Because the public interest in finding a cure on one hand, but there's a public interest in maintaining privacy because that's a public asset, not to be wasted.
Yes, I just wanted to go back to one statement that, in fact, there is an issue with secondary use, and we all agree to that, I think. I just wanted to open a new door for discussion. When I read the directive, if you look at the Directive 95/46, you have, I think it's Recital 29 and also Article 6, which makes somehow an opening in relation to so-called scientific research, and which says that you can process data, further process data, and this is not incompatible with the initial purpose. I think this is certainly, and I agree with you, what is scientific research? We can discuss whether a purely clinical trial in the framework of the development of a new medicinal product would fall under that definition. My view is that the answer is yes, but okay, this is something we can certainly discuss. And that would mean that there are certain provisions in the directive that would no longer apply, where there would be an exemption in relation to secondary processing. I think that's an important point.
So I'll just comment back that I think, while the directive might say that, how that's actually been implemented in the member state laws is not necessarily consistent in every country, which
that's
creates
subject,
challenges.
and that of course raises the issue of harmonization, because you may have 27 different solutions.
Did you have a comment?
Well, yeah, just to, one of the things we keep talking about too is this data flow and data flying all over the place. And, you know, when you really take it down and think about it, when you want to do a genetics research study, for instance, even if you go to the Broad Institute, which is one of the largest research institutes as far as the data they generate, and when you ask their scientific community how many people actually go in and look at the data and run the analytics, which was a big discussion this morning, it's like 2 or 3 people. So not that many people even know how to analyze these data sets. And so having a model where you can make data accessible to the extent that an expert in a disease area might come forward and say, I would love to ask this question of the data, but I don't have the expertise to run the algorithms. Would you do that for me? And that's a really great way to protect a data set from open access and have it flying all over the place, but still make it accessible. It's sort of like the US model for our census data, that you can't have access to it, but you can pose questions to it. It protects the sanctity of the data, but it also allows all kinds of research to go on and to get the anecdotal or the, you know, some of the other information that might fall out of it. And the aggregated information is really important. And that's really what researchers want anyway. They don't necessarily want all of the bits and bytes. They just want an answer to come out of it.
Thank you. So I know, Marty, we'll take your question, and then I think we do want to spend a little bit of time just going through the framework of issues that we think are really critical to designing privacy into personalized medicine. I want to make sure we have time to cover that at a high level, and then we'll take more questions. But Marty, do you have a question? Okay, so I'm actually going to turn to Devin and ask her if she'll sort of walk us through. So we talked a lot about consent, so we won't talk more about consent at this point. I'm sure it will come up again. But in terms of alternative approaches to transparency and to privacy and data protection, Devin, could you walk us through some of the other things we should be thinking about?
Sure. So I don't know that I would necessarily put myself in the camp of alternatives to consent necessarily. I mean, we've actually done a fair amount of writing about the significant limits of consent when you over-rely on it to protect privacy. But what I would like to say is, if you think about the full complement of fair information practices, it's just one element. Yeah. And so whether it's present or whether you think there's justifiable reason why you would not need to get it, it would in no way be the only thing that you would think about. You would think about the point that Linda raised. Who has access to the data? How many people? When you can narrow it to a very small class of people, you have really exponentially improved the privacy protection. It was really, I mean, I guess, I suppose if that one person is your neighbor, that could be problematic. But in general, I think it works better the fewer people have the data. That's one of the reasons why we call for distributed research networks, so that it's not everybody who needs to do the research collects all the data themselves. And so therefore, at the end of the day, we have hundreds of thousands of databases with the same data in it. Bringing the question to the data is another way that we refer to it. So, whatever formulation of the fair information practices you use, the data minimization concept is one of them. Collect what you need. Don't collect more than what you need, but if you need it, collect it. Just depends on the question that you're trying to address. Accountability is another piece of the framework. Who are you answerable to for complying with the set of practices that you put in place to protect your data? Compliance with the law is at the baseline level, but to the extent that privacy by design needs to be flexible enough to meet the demands of the particular research project or clinical care protocols that you're putting in place, you're going to have to, as an industry stakeholder or a researcher, put that into place. And are there sort of best practices or standards or some way to be accountable for what you're doing? Data use agreements is one mechanism for assuring accountability. But I think we always need to, too often, many regulators, certainly not any of them in this room, think narrowly about privacy protection and think about it as a consent issue. Well, if the patient says okay, then we've sort of got it covered, and it's a big it's a burden to actually think about it in a much broader way. But when you do that, you actually find you will get much better results. And ultimately, if what we're trying to do is build the trust framework, I don't think there's any way to do it but to think about it in that comprehensive way.
Thank you. Does anyone have any comments in response?
Well, again, I think we should read the law, and in my view, there are certain exceptions to the consent. Well, if you look at the directive again, you have the vital interest of the data subjects, of the patients. That, of course, is probably an issue to determine from a factual point of view, but you also have the cases where there is an intervention of a health professional in relation to diagnosis, to treatment, and so on. And also, I think there is an exception, well, a broader exception in relation to not necessarily health professionals, but people having the same level of secrecy obligations. And that, I think, is also a way out to avoid necessarily, in all occasions, the consent. By the way, on consent, I also wanted to stress something, which is the definition of consent under the directive, which, as you know, required to be free, specific, informed, and so on. Specific, I think, is a big issue, of course, if we want to go in the direction of secondary use, because then we have an issue of purpose and incompatible purpose for the next step of the review.
Hillary told me to behave on this panel, but I will not behave in that way. And I will say the following, and this is because I truly believe that we need to do something to relax the angst around this my sample kind of notion. And that is, as I stated earlier, and in my humble opinion, should direct legislation and regulation on that. And that is, we have to add the reasonable aspect to the notion. And in the United States, 2 years ago, the authorities said that a sample that is non-identifiable can be used without consent. And they said non-identifiable is that a specimen that cannot be identified without unreasonable effort. I mean, they can hack the Pentagon, they can hack. So we understand that there is a limit to what we can set as reasonable. once we get that notion, then we realize that those sample mine, it's not so much. I mean, after all, like I said many times ago, we are 99.9% identical. So is it really my sample? I mean, Hugo said in 2004, the human genetic makeup is part of human heritage. What's the legal and ethical and normative sequela of that statement? Clearly, guys, clearly it means that my proprietary interests and my control interests, which are important, are still amongst other interests we must rely on, and therefore the consent and secondary use and everything should be subject to this overriding principle that there's something bigger than me. Thank you.
And thank you. And I think, I mean, it's a really important point to think about that I believe it's about 99% of our genomes we share amongst each other. And it's only that small, approximately 1% or so that's different among us. So an important thing to think about, not just the individual rights, but the group and community rights that exist as well. One of the things we did want to spend a little bit more time on around individual and group rights is the right of access, which is particularly unique in the context of genomic data, especially as it relates to basic research and translational research. So I want to come back to Gil in a moment on that. But before we do, leave the topic of coding and, is DNA, can you de-identify DNA? We talked this morning, and the panel this morning did a wonderful job about talking about anonymization. And I think we really need to make sure we don't lose sight of the fact that if we're saying that you cannot truly anonymize, which in the context of DNA is a really important question, then what are the appropriate standards for privacy and data protection? We really want to encourage thinking about a set of standards that is appropriate and allows, especially in the context of health and genomic research, that allows for innovation, that allows for the continued advancement of the public health, for respect of individual and community interests, but that is not going to impede the further development of research. So I just ask you all to think about that as we move further through this panel. But I want to turn now to Gil and ask him to introduce some of the really important ethical issues that are at stake in providing a right of access to individuals, to family members, to communities around genetic research results, and some of the concerns that exist there.
But there was a guy, if I just was really wanted to ask a question there. Marty, you want to ask a question?
I'm sorry.
There was, yeah? Okay, so. Okay. All right, so I'll be very brief in my short remark on the access issue. Well, access should be subject to different rights or privileges according to the need that we're in. I mean, I think one of the strongest waivers of right for access really belongs within the family. So the right of family members is something that in many societies the access there seems to be more lenient. Basically, I mean, if we talked about before the human heritage issue, so in the family it's how much more so. So in many regulatory frames, access for family members has been regarded as something that we should be more acceptable with. So if a family member comes and says, listen, I have breast cancer, but I dare you do not tell my sister, my mother, my aunt. So this right of shielding and holding back information because she hates her sister is something that we regulators should be very wary about. And the right for family members is something that and many regulations have been granted. There is ways of supervising that. In Israel, we have an ethics committee. In Israel, in the United States, in the state of New Jersey versus the state of Florida, there were different legal ruling on the right of family members and the duty to warn. So you have to understand, because if there's a right of family member, that creates a duty on part of the treating physician. So you, the doctor who knows she has a sister, it turns your duty and therefore your malpractice litigation, if you don't perform your duty, to report that. So the right of family members to know. Funny enough, there is a right not to know. So if there is no clinical utility, so is there a right on family members not to be bombarded by this personalized information that might not give them any benefit? So that's the first realm of right of access. The second realm of right of access really pertains to the legal entities such as security, the police, investigation, everything. We have very interesting cases where a murder has been took place in some sort of a university-based city, and the police knows that many of these young male students that are powerful could have been part of the student body, and those students, when they enroll, they give a piece of their skin, their saliva, whatever, for genetic on 23andMe. Not your company, 23andMe. And then, so should the police have access to that research, repository in order to find out who committed that crime? So that's the second level of access to information, genetic information, medical information. And the third will be for the research community. Now, in the research community, again, we have different and varying legal regimes that governs that, and clearly, if we accept the notion that reasonable de-identification is something that is acceptable, then what flows from it that the information that has been gathered should be regarded as a public good, a collective public good. And once that is the notion, then you can ease the access of the scientific community to that databases, and the NIH had all those repository on, and open access codes, and the commons ideas. So there's a notion going there. All those notions are bottom up. The question is, should we have that notion in a top-down fashion? And again, I dare to think about that option as well. I think that covers most of the points I wanted to make.
Yeah, thank you. Yes?
Along the wall. In the back.
Maybe while we are waiting for the microphone, I just wanted to add one additional point on the access issue, which is the international perspective, because we haven't really talked about it so far, but there is, of course, the issue of data transfer. And Professor Miyashita mentioned the Declaration of Helsinki. I know that the Declaration of Helsinki is extremely general in relation to privacy, but we may think about this as a forum, because this Declaration of Helsinki is reviewed on a regular basis, as we could expand it and also resolve part of the issue regarding data transfer. I think that would be certainly, because the problem, of course, is that we can resolve data transfer in relation, for instance, to the EU member states versus the US, for instance, or try to implement whatever standard clause you like, but at the end of the day, we also need a global solution, because all this is being done at a global level. So a Declaration of Helsinki might be an instrument, there might be others, we may design a completely new one, but the good point, I think, is that this one is existing.
Thank you.
Thank you. You've almost given the answer I was going to give, which is, let's be careful not to reinvent too many wheels here, and here are two examples. The Australian privacy law regarding research, I think, is probably fairly similar to the case in a number of others, for example, the IRBs in the USA, which is essentially says you can have access to, an ethics committee has to decide if information about a person can be accessed for research without consent, but it puts it through a sequential test. Can you conduct the research with de-identified information? Only if you can prove that you have to have identified information do you move to the next test, which is, is it impracticable to achieve consent from the population you want to involve? Only if it fails that test do you go on to the third test, which is that the public interest in the research outweighs the private interest in privacy. Note, I say parenthetically, the questions are not asked about the private interest in the research, which is often very strong, and the public interest in privacy, which includes simply turning up to get your treatment. So I do think there we already have some constructs in place that answer some of these questions. The second thing that might be useful for people in the audience is that in Australia we have a very interesting body called the Australian Law Reform Commission. It's government funded but independent of government and all other interests. In about 2006 or 7 it published its inquiry into genetic privacy, and the report is called Essentially Yours. The website from which you can download that whole report is www.alrc.gov.au. At the time the report came out, it was acknowledged worldwide as the best report on genetic privacy ever conducted in the world. It has specifically addressed the issue of familial access to the genetic record of a particular person tested, and set out a pathway by which somebody who wasn't the person who was the subject of the test but might benefit from knowing about the results from that test through genetic relationship could be told of those developments. Some of that has already been passed into Australian law. So I would suggest that we actually do have some well-documented, well-thought-through materials that allow us to begin to answer these questions without starting de novo. Thank you.
Thank you, and I agree that there are definitely a lot of good standards that exist already to address a number of the more traditional approaches to research, the people who are in the healthcare provider space. But to your point, there are people in the private sector. There are now, as all of work is done around the globe, so many different collaborative institutions that are involved, whether they be private, whether they be public, whether they be government entities, and oftentimes, at least under existing legal frameworks, they aren't regulated in the same way. And so how do you ensure, just going back to the concept we've been talking about frequently now of accountability, how do you ensure accountability among all of those different parties? So it looks like you have a response. Marty, you...
I think that is a particularly important question because company response to a piece of law is a risk management process. They assess the likelihood of enforcement happening and they assess the impact of law enforcement should it be put in place. So in Australia we have a privacy law which is deliberately, as announced by government, light touch regulation. It is not actually up to speed for the purposes of some of the questions we've got here, even though the law makes certain things illegal, because you need to think about the 3 mandates for a regulator. What the law gives them in terms of power, what the government gives them in terms of money to exercise those powers, and whether the government will actually stand behind them should they actually exercise those powers. Lack of some of those 3 things caused a global financial crisis.
But if companies want to do the right thing, assuming that, and I'll speak from a company perspective, assuming a company wants to do the right thing and actually has a primary focus on minimizing risk of harm to individuals before even getting to whether a law is going to be enforced or not, how do you, are there proper frameworks that are in place today to address those requirements and ensuring accountability amongst all the different parties?
Well, I think if we had it to completely nailed down, we wouldn't all be sitting here.
Exactly.
But on the other hand, so another way to think, one of the things that we've been beginning to talk with regulators about is safe harbors. Where if you set criteria above and beyond the law and you meet those criteria as a company, and of course there'd have to be a way to independently and objectively judge whether you had met them, then there's a reward for doing that, whether it's an exemption from being sued in a US court, for example, or something that creates the value proposition for you to pursue the higher level of protection, but that still enables you to do what you want to do. It's sort of privacy by design wrapped in a safe harbor. Privacy by Uber design, one might say. So
we had 2 questions in the second row and third row. Excuse me.
Thank you. I guess I've had my hand up and down a lot, and I think that there are some key points that would be useful to add to the perspective here. First of all, we shouldn't take this session as a silo away from the other sessions. There's really been some important things in the other sessions that need to be brought back to this one. A couple of them have to do with we're now in an incredibly unique period where we're writing the next generation of information policy law. We're writing it in Europe, we're writing it in the United States, we're putting principles into effect in the Asia-Pacific region, that there is a lot of rethinking that's going on. And part of that rethinking goes to the fact that we're learning more and more that information policy is contextual. It's contextual to multiple factors, and that it's not always useful for regulators to be in a position to second-guess the context, but to be in a position to second-guess the process. Part of the reason that privacy by design is so important is it's a formula for a rigorous process within organizations. And it says that there's this rigorous process that you need to take. What you add on top of that in concepts of accountability is you're not just responsible, but you're answerable. So answerable in the very minimum level stands that you're ready to demonstrate the rigor of your process. And when you begin to marry those concepts together, and you begin to create the framework that allows organizations to be flexible, and to be flexible in the way they apply principles, but in an algorithmic way and not in a mechanical way. So when we talk about data minimization is in relation to the context of what you're doing. For example, yesterday I said when you're building fraud tools, you have to use huge amounts of data, but you counterbalance that with security measures that are just as huge and just as robust. But again, you need to have this system of being able to demonstrate. The concept of safe harbors is a mechanism for validating rigorous process and having similar rigorous process that can be trusted and jointly developed. When we think about the panel that was next door right before lunch, the panel on ethical analytics and anonymity, one of the things that was coming out in that at the end is that the current generation of law is not overly friendly to a highly analytic society because it has not really put on a regular basis the context of the principles taken together, and has never left the freedom to understand the data before you get into the application of the data. And we don't separate the application and the understanding of the data, which are two different things. So I think that so first of all, we shouldn't be bound by, in thinking about the future, thinking about what the current law is, because the current law will absolutely change. Even in Europe, it's going to change, and change significantly. The second, we have to think about it in contextual ways. We have to think about the way that organizations are both responsible and answerable, and that the license to be innovative with the data is the rigorous process that is demonstratable. I guess that wasn't a question, but...
It's a good point, though.
Okay, so we have another question, and then and we want to take as many questions as people have. We are close to the time, and we do want to make sure we emphasize the takeaways that we had as a panel. But first, we'll go to the question.
Since Bernie and Malcolm, since Bernie and Malcolm want to make a statement, I'll just make the statement. I think Graham Lowry's. I think that Graham Lowry's work should also be recognized when you talk about family rights for accessing information. Is equally, you have family rights for keeping everybody apart, and it's a whole thing beyond what we have time for here. What I was hoping we were going to hear today in personalized medicine was gone.
You're not cut off yet.
What you were hoping we were going to hear
was something about the dialogues on social networks and so on, where you're having patient-to-patient, either grassroots or sponsored. Because I know my colleague from Toronto, Ronnie Friedman's here, and I work with Yank Luke in Toronto. There's a lot of this going on in Canada and I'll bet elsewhere, where you're having hospitals or others, or private companies even, who are trying to sponsor patients getting together, often based on the theory of having a common problem, but more and more I hear that it's having common DNA or common genomic characteristics. Is there time to just hear something about that?
So I'm going to turn, if I could, over, oh goodness, to Linda, because that means certainly that's a component of 23andMe. And just given the time that we had, we could talk about this all afternoon. And certainly, even in the clinical study recruitment, patient recruitment context, there's definitely a social networking component to that, which I don't think we have time to talk about right now. But I think the 23andMe example is a really good one around the communities, the patient communities that are being
Absolutely,
formed.
yeah. So it's a combination of people who share a disease disease, and then they can go in and actually explore their genomes together. And the combination of that is very powerful, and it just creates a community that is so strong, and the sharing and the openness that goes on in a very closed-off space. That, you know, it's kind of a different model versus something like Patients Like Me, which is, it's part of that is the requirement is it's out on the web, it's open completely, and I think they have different alternatives to that now for depending on the communities. But the point is that, and we learn this with studying obesity and these types of things, right? That in your community, it's almost like a meme that goes through, that you influence each other in very important ways, and we've really kind of avoided that in healthcare. And if we do create communities around a disease or a topic, there could be so much power in that of us coming together and coming up with ideas and sharing information in ways that researchers would never know to ask. And you start to see these threads and commonalities that really emerge, and there's pattern recognition software that really recognizes a lot of this that's really powerful. So I do think that social research is going to become the way research gets done, and having it be consumer-centric and share information that we wouldn't even know to ask, and then let the computers tell us what the patterns are and what the outliers and what things are popping out that then we can pursue and we can go after. That I do believe that is the model for the future, absolutely.
So I'd just like to quickly summarize, and then of course we'll take any additional questions that people may have. So a few points. I mean, we talked about a lot. We could have talked much longer about these very fascinating issues. But a few points we did want to leave with you are that, as we discussed, a new generation of medical advances holds great promise for each of us to know our own genetic makeup and to receive healthcare treatment that's actually tailored to our unique genetic profiles, hopefully more effective, less likely to cause adverse events and otherwise. Innovative technologies, methodologies, and cross-border collaborations in this area, as Tanguy mentioned, should be designed with privacy and data protections built in to minimize harm, ensure compliance, and demonstrate accountability. Policymakers should encourage and enforce accountability by those who process genetic information and materials based on flexible requirements that can be adapted to evolving technologies and methodologies, including things like we're just talking about here at the end, social networking being a component thereof. And finally, approaches should be based on a framework of bioethical principles, as Gil mentioned, data protection and cultural and community perspectives, avoidance of harm, and a broad approach to transparency rather than a focus strictly on the primacy of consent. With that, I'll thank you all for your participation in our panel. It's exactly what we were hoping for, and if you have any other questions, we'll be happy to answer them.